Friends, buckle up, because today we're diving headfirst into the wild, wacky, and occasionally utterly absurd world of intellectual property law. Prepare to have your mind blown, and maybe even spit out your coffee, as we unravel the chaotic evolution of protecting ideas, inventions, and creations. We're talking centuries of legal battles, questionable rulings, and enough bizarre case studies to fill a library the size of the Library of Congress. Let's start at the very beginning, a time before copyright, patents, and trademarks even existed. Imagine a world where someone could steal your groundbreaking invention, replicate your masterpiece painting, or even copy your catchy jingle without consequence. Sounds like a nightmare, doesn't it? Well, that was the reality for centuries. Early forms of protection were rudimentary at best, often relying on guild systems or royal patronage. Think of it as intellectual property's dark ages, a chaotic free-for-all where innovation was constantly threatened by blatant imitation. The shift began slowly, with the rise of printing presses in the 15th century. Suddenly, the ability to mass-produce written works exploded, creating a need for some form of protection against rampant copying. Enter the Statute of Anne in 1710, considered by many to be the cornerstone of modern copyright law. This landmark legislation in England granted authors exclusive rights to their works for a limited time, a revolutionary concept at the time. I wonder what the reaction was to this. Did the publishers throw a massive party? Or did they stage a dramatic protest, convinced this was the end of their lucrative world? But the path to modern intellectual property law wasn't a smooth one. It was a bumpy, often hilarious roller coaster ride filled with legal loopholes, ambiguous interpretations, and some truly baffling court decisions. Take, for instance, the early battles over patent rights. Imagine inventors squabbling over who invented the first improved mousetrap, a legal battle that would probably involve more cheese than actual legal argument. And the lawsuits. Oh, the lawsuits. Some of the early cases read like comedic plays, with inventors accusing each other of everything from outright theft to blatant plagiarism, with the occasional dash of witchcraft accusations thrown in for good measure, just to spice things up. The 19th century saw a surge in innovation, fueled by the Industrial Revolution. Suddenly, patents became crucial for protecting inventions, from steam engines to telegraphs. But this era also witnessed a surge in patent disputes, often incredibly complex and drawn out. Picture this. Imagine a courtroom filled with intricate mechanical diagrams and lawyers arguing over the precise angle of a gear or the subtle difference in a piston's design. I bet the jury was absolutely thrilled. You'd think they'd be handing out prizes for the most creative interpretation of a technical drawing. The 20th century brought about the rise of trademarks, branding, and the concept of intellectual property as a valuable asset. Suddenly, logos and brand names weren't just identifiers. They were powerful symbols of quality, recognition, and market dominance. This led to fierce battles over trademarks, with companies fighting tooth and nail to protect their brand identity. Some of these cases involved absurd situations. Remember that time a company sued another for using a similar shade of blue? I mean, seriously. You'd think they'd have more important things to do than worry about the precise hue of their corporate color scheme. The latter half of the 20th century and the dawn of the digital age introduced a whole new dimension to intellectual property law. The internet, with its ease of copying and distribution, presented unprecedented challenges. Suddenly, music, movies, software, and even digital art could be replicated and shared with ease, leading to a wave of copyright infringement cases. The music industry, in particular, fought a long and arduous battle against piracy, with varying degrees of success. I wonder what the pirates were thinking. Did they really believe they could get away with it? The audacity. The rise of the internet also gave rise to new forms of intellectual property, such as software patents and database rights. These areas of law are still evolving, constantly adapting to the rapid pace of technological advancements. It's a fascinating, if confusing, landscape. We're still grappling with the implications of things like AI-generated content. Who owns the copyright to a painting created by an algorithm? It's enough to make your head spin. And let's not forget the international aspect. Intellectual property law isn't just a national affair, it's a global one. International treaties and agreements attempt to harmonize intellectual property rights across borders, but navigating this complex web of international laws can be a real headache. Imagine the international legal battles, lawyers from all over the world battling it out in court, each with their own unique legal systems and interpretations. It's like a global intellectual property cage match. The evolution of intellectual property law is an ongoing story, constantly adapting to the changing technological and social landscape. We've come a long way from the rudimentary protections of the past, but the challenges remain. As technology continues to evolve, so too will the laws designed to protect intellectual property. And who knows what bizarre and unexpected legal battles the future holds. One thing's for sure, it's going to be a wild ride. Perhaps one day, we'll look back on these early struggles and laugh at the absurdity of it all, or maybe we'll still be arguing about the precise shade of blue used in a logo. Only time will tell. But one thing remains certain. The quest to protect creativity and innovation will continue, no matter how chaotic the journey. The fight for intellectual property rights is a never-ending saga, a constant game of cat and mouse between creators and those who would steal their work. And that, my friends, is a story worth telling.